Okay.
All right. So welcome this afternoon. Keith was just telling me that he's studying Italian for his upcoming Italy vacation.
I'm trying to. Yeah, it's a great language, but yeah, I haven't learned a new language probably ever, but I'm trying.
Do you think you'll be able to talk to the people?
I hope so. I hope I'll say a few words, but a friend of mine said that, well, you'll go to Italy and they'll ask you not to speak Italian because they speak better English, but we'll see.
Welcome, Jury Pool, and welcome to everyone who's joining us. We wanted to spend a little time at the request of the Jury Pool on some of the lesser known people in this case. They're still important people, but they're lesser known. Stephanie Jones, Jennifer Abel, and Jed Wallace. And Keith and I have been busy going through a bunch of legal filings when we probably should have been doing legal work for our firm. But this case is starting to take us over. So
yeah, it's our full-time job now. Yeah.
It's our full-time job almost. So Keith, why don't you walk us through where you want to start, and we'll kick it off.
Well, I think we want to start looking at the Abel versus Jones counterclaim, and it's very interesting that, of course, Jones sued Abel in New York State Court, is how that started, and then Abel removed the suit to New York Federal Court. So they're in the same court as the Lively versus Baldoni under a different case number, but same court. And now Abel has come in and filed her answer and cross complaint. And we get started on the cross complaint on I think I'm on page 33.
Real quickly, Keith.
Yeah.
When somebody, a lot of people are asking procedural questions because they want to know the nuts and bolts. And so there was a lawsuit filed in New York State Court.
Yeah.
And that gets removed to federal court. Walk through how that works.
Yeah. The reason it got removed to federal court is, again, going back to diversity jurisdiction. So there's only two ways that you can bring a case in federal court. Either it's what we call a federal question. So you're filing something under federal law.
Has to do with the Constitution or some law that Congress passed.
Federal statute.
Okay.
Or you have diversity of citizenship, meaning the plaintiff is from one state, defendant from a different state. You can go to federal court.
So who were the parties here, and what states were they from?
Here it's Stephanie Jones, New York, and Jennifer Abel, California.
Okay. And so there's a lawsuit filed, and who does what?
Once Stephanie Jones files a lawsuit in state court, then Jennifer Abel would go to federal court and ask that the federal court take jurisdiction of that case and have it removed to federal court. The federal court will then issue an order telling the state court to transfer it on over, and then it gets transferred over to the New York federal court, and it becomes it'll be handled by the federal court at that point.
So we had a case in New York State Court. It gets withdrawn up to the federal court, and that's where it's at now. There's been a complaint, a lawsuit filed by Stephanie Jones, and now we hear Jennifer Abel giving us an answer and a counterclaim. Is that right?
That's right.
So is that Jennifer Abel's own lawsuit against Stephanie Jones?
That's right. It's their own lawsuit against Stephanie Jones. It's what we call a countersuit. And so that's what we're looking at. And of course, Jennifer Abel, she's going to be asking to use California law in this lawsuit. We've seen a lot of that conflict of law stuff going back and forth. And that's what's no different here.
All right. So we're on page 33 of the, it's actually a first couple pages of the counterclaim, but it's page 33 of the document that was filed with the federal court. So where do you want me to go?
I like the paragraph 11. So this is kind of their introduction of Stephanie Jones. So the long known within the public relations industry for her disarming Southern twang, and then go down to the next page. Brass knuckle tactics and high turnover of clients and employees. Stephanie Jones has had a successful career in the entertainment industry. So right there's kind of a shot across the bow of this is essentially what they're saying is this is who we're dealing with. So Jennifer Abel saying this is what Jones is all about. So I just thought that was an interesting way to start up the lawsuit. And then you had paragraph 13 highlighted there.
I didn't really want to talk about that so much, but 15, are you talking about 15?
Yeah, 15.
Go ahead.
So this is interesting in the sense that they're laying the groundwork for what happened. So apparently Abel was poached away from her prior employer to go and work for Jones Work. And Jennifer Abel saying that she had an array of well-respected public relations professionals from across the industry who reached out to her and cautioned her against working for Stephanie Jones. So that's her allegations. I just thought that was kind of interesting. And Jones, they warned, had a well-deserved reputation for treating people horribly. And Jones had recently become embroiled in a dispute with another public relations firm for stealing its clients and using deceptive and unscrupulous means. So I don't know what firm that is, but those are the allegations. And again, why would you put this in here as to how she came to work for Jones Work? I think you're trying to give a flavor of the background of who you're dealing with.
And I think this also, for the jury pool, this will educate all of us on the litigation privilege. And that is, if you say anything in a filed complaint in court, you cannot be sued for defamation. And think about how defamatory these statements are if they're not true. Now, they probably are true, or at least there's some truth to them. But if just look at this, that she has a well-deserved reputation for treating people horribly, and that she recently became embroiled in a dispute with another public relations firm for stealing its clients using deceptive and unscrupulous means. They're essentially saying that she's a liar, cheat, and a fraud. And they're, for how she's abused somebody else out there. Can Stephanie Jones in any way, shape, or form sue Jennifer Abel for making this horrific, some very strong claim against her?
Not for defamation, because litigation privilege. So both parties are allowed to say whatever they need to say, whatever they want to say within the confines of the lawsuit. So pretty strong words. And, again, I think that they're coming out punching hard.
All right.
Against Jones. And so on the next page, we're going to get into, there's two different employment contracts here. There's one from 2020, one from 2021. It's going to be pretty interesting, kind of how this works. And the thing that I found interesting about the 2020 employment contract is this huge confidential information provision where there's just, and it goes on. I mean, this is just the beginning of it. It goes on for quite a while. And in particular, essentially, it's obligating Abel to keep client information confidential, or anything that has to do with the firm confidential. Anything that's non-public is confidential. Any data or information that is proprietary to the company and not generally known to the public is confidential. So it goes on and on about all the things that you have to keep quiet about.
Yeah, and that's something that was a duty on her according to this contract. She cannot disclose things about the clientele. She also couldn't disclose things about Jones Work and how they handled their affairs.
So the allegations are not that Jennifer Abel disclosed anything. It's that Stephanie Jones disclosed something. Why take up a page and a half in this pleading talking about the confidentiality agreement and the employment agreement?
Well, I think we're going to see here in a minute that what's good for the goose is good for the gander. And many people were upset that California law gave such protections to Blake Lively under 47.1 of the Cal Civil Code. But we're going to see that California law gives every employee a lot of protections. California is a very friendly state for employees, and it's not so friendly for employers. And here you have Jones Work being the employer, and you have Jennifer Abel being the employee. So you're going to see that Brian Friedman is actually going to be effectively arguing that California law should apply here, and he likes California law. And we're going to find out why in just a minute.
Yeah. And I also thought that the reason they spent all the time talking about this confidential provision is they wanted to show that, look, this is what Stephanie Jones made Abel agree to.
Right.
You have to keep everything confidential.
Right.
But now their allegations are going to be, but she didn't hold herself to that same standard.
Even though she had an agreement to keep all of Wayfarer's information confidential.
Yeah. So, I mean, I kind of felt like they were trying to show the juxtaposition of what Abel was required to do under the contract. Well, what about Stephanie Jones? Why didn't she do these things? So I think that was kind of what I got out of these allegations.
Here, guys, speaking of contracts and employers, thanks, Paula, for this question. This is kind of the question of the day, I would say. She asked, did you watch the video from Without a Crystal Ball? That's our friend Katie, who we'll soon be collaborating with. Apparently, Blake was not an employee, and she can't use California laws as she likes. She was employed by herself through her company, being a contractor. What's your kind of analysis on this? Because there's a lot floating around.
And first of all, I want to say that Katie at Without a Crystal Ball has done some really good work in this case. I've enjoyed watching her channel, and she's getting us all to talk about this. We're not only talking about this issue, the independent contractor versus employee issue, we're talking about the case, and she does some really slick productions, and I only have admiration for her. I would say that she's partially right and she's partially wrong. Partially right in the sense that under Title VII, it's a federal law, there is no protections for independent contractors for SH and those types of claims. But here, as we just talked about, California law is really good for employees. And back in 2019, California legislature, in its infinite wisdom, decided that independent contractors would be covered under the FEHA. It's FEHA. It's our applicable law to Title VII, the federal law that protects against certain types of discrimination. And so what the FEHA says is it'll cover employees and independent contractors. And so I understand that there's an entity by the name of Blakel or something like that, and that's what contracted for Blake Lively to do her work on this film. I don't think it really matters under California law because it's a FEHA thing. Do you have anything you want to add to that, Keith?
No, I would agree. I mean, it's just so widespread and liberal for employees here. And I mean liberal in the sense that the law is very wide and allows employees to have a lot of rights. And that includes, under California law, the independent contractor. So there's going to be a big argument. I'll bet you anything when we see the opposition to the motion to dismiss for Lively, there's going to be a big argument over what state laws should apply. But we'll have to see what the judge does with that.
Yep. And I do want to thank Katie at Crystal Ball, Without a Crystal Ball. Keep your good work up. You're getting some good discussion started. I mean, I did see lots of people talking about this online. So kudos to you for getting the issue out there, and let's all attack it together and see if we can figure it out.
Yeah, Liz says, thank you for addressing the, in quotes, smoking gun. Melanie King is here too. She says, is anybody, I saw this earlier today. I don't know if you guys did. Melanie King says, is anybody talking about the fact that Stephanie Jones is married to a senior partner at WME? His name is Jason Hodes. WME is the, talent agency that reps Lively and Ryan Reynolds.
Yeah, I know. That's so connected. And I noticed that. And within this complaint, we'll see it a little bit later, there's actually a text message from Stephanie Jones's, I guess, husband or something, to Jennifer Abel's fiance, trying to convince him to convince Jen Abel to stay at Jones Work. I mean, what the heck is going on? These people are like so connected.
It's a very tight community up top. By the way, Melanie King, enjoy your work on this stuff, and I appreciate everything you've been putting out. Yeah, I think that's the right Melanie King. Is that right, Eric?
Yep, that's correct.
Yeah, she's doing a good job, and I've been enjoying her videos.
Yeah, fantastic work. And yeah, but it's very interesting, all the behind the scenes things. Of course, we're focusing more on just kind of the legal claims and the allegations, but that is really interesting. And we'll have to see how that shakes out in discovery. Because more will come out. There'll be depositions, there'll be, documents, there'll be, who knows what text messages there are out there that we haven't even seen yet.
Yeah, there's going to be a lot, and we're going to see, I mean, as soon as the discovery gets started here, are there going to be leaks? We're going to find out. Some people have asked about depositions. Unfortunately, we will not be able to watch the depositions. We'll have to wait to a trial to actually see clips from those depositions played on a screen. Although this is federal court, chance of getting a camera inside a federal court is almost zero. Yeah. So I'm not certain we're even going to be able to see what's happening inside the courtroom like we did with the Johnny Depp trial.
Well, what if there was text between Stephanie Jones' husband and Ari Emanuel about Baldoni and this whole mess? I mean, that would not be privileged. That'd be something that you could get a hold of through a subpoena.
Very relevant too, if it's about this issue. So yeah, that stuff's going to come in. Yeah, who knows what documents are out there. There's a universe of documents that people are still getting, and there's going to be some very happy people as those documents are disclosed, and there'll be some very sad people.
I'll bet you the subpoenas are being drawn up right now. If they haven't gone out already, they're probably, putting the ink to the subpoena right now. Let's drop down and look at the 2021 employment agreement. So the interesting thing about these agreements is, as you would imagine, is they try to be very favorable for Jones Work, the employer, which you would expect. And apparently in 2021, a new agreement's entered into, and it goes from being an at-will employment to contractual employment for a term. But what do you know? They have a big, long confidentiality section in here once again, and it obligates Abel to keep all sorts of things confidential. And on the one hand, you're thinking, well, what does that have to do with whether the contract was breached or not by Abel? Well, nobody's claiming that Abel disclosed anything. But on the other hand, I think they're showing that, well, this is what Stephanie Jones made Abel agree to, but Stephanie Jones doesn't seem to be holding herself to the same standard.
Yeah, the hypocrisy there.
Yes,
I think it's a good point.
Now let's drop down, because I want to show how these agreements are going to work in California law on page 42, because California actually has a labor code, section 925, that specifically talks about whether or not these type of contracts are enforceable and whether they can be enforced against an employee. And I think it's very interesting how this works because California has a strong public policy that we don't want employees to be locked into contracts that do certain things. And you can see under A there's two things that an employment contract cannot do. It can't require the employee to adjudicate outside of California for a claim arising in California, and it can't deprive the employee of the substantive protection of California law. So the question becomes, well, where did the employee primarily reside and work in this case?
And I think that's the important thing here is we have a New York firm, Jones Work, that is hiring an employee to work in California for their California-based clients. They want to have a Los Angeles-based office. And so when a New York firm hires California employees, the California employees are under the protections of California law. And there's some things that California is going to say to a New York employer, you cannot take away from a California employee. And that's what we're seeing happening here. And this is the brilliance of Brian Friedman. He's doing the same thing that, what was the lawyer's name in the 12b-6 for?
Ezra Hudson.
Ezra Hudson. Doing the same thing Ezra Hudson's doing with Civil Code 47.1. It's very broad. It's very protective of the employee. And here, Brian Friedman is using Section 925 to essentially void the employment contract that Jennifer Abel had with Stephanie Jones and Jones Work.
Yeah. I mean, it's a different code section. He's not using 47.1, but he's using California law to his advantage. And you can see there where you have underlined, it's voidable by the employee. So the employee could choose to enforce it if it's favorable to the employee, but the employee has the election to consider it void. And look under C. What do we see here?
Well, before you get, oh, sorry. Yeah, that's it. Go ahead.
Yeah. So in addition to injunctive relief and any other remedies, a court may award an employee who is enforcing his or her rights under this section reasonable attorney's fees. Now, the only thing I don't like about that is the word may.
Yeah.
So what's the difference?
Because under 47.1, it's mandatory.
Shall.
It shall. The attorney's fees have to be done. So when Ezra Hudson argued 47.1 on behalf of Blake Lively, she's got this very strong stick because she can hit the other side with the idea that attorney's fees shall be awarded if we're the prevailing party. Here, it's up to the court. The court may or may not award depending on the circumstances. But it is a provision that allows for reasonable attorney's fees, and so it's at least a starting place.
Yeah, exactly. So it's a very strong law for Jennifer Abel, and I think she's got a great chance of being able to get these agreements voided.
And by the way, there was a communication from Brian Friedman and his legal team to Blake Lively and her legal team that they are electing to void the contract between Stephanie Jones and Jennifer Abel.
Oh, okay. So they've made that clear.
They have.
And you would expect that to be the case. The thing that I find kind of funny, just to give this some perspective, is that the Jones versus Abel suit started because Stephanie Jones sued Jennifer Abel to enforce these contracts. And you kind of stand back and scratch your head a little bit and go, why would you do that? Why would you file a suit to enforce a contract that an employee can deem void?
Yeah, Stephanie Jones filed this lawsuit against Jennifer Abel, I think back in December, but or maybe it was early January. And then of course the removal had to take time from state court to federal court. And now finally we see Jennifer Abel responding to this lawsuit. And she's saying, oh, by the way, you guys didn't look at California law, but California law allows me to void the contract that you're trying to enforce in your lawsuit against me. This is one of those times where we say, Keith, if you're going to shoot at the king or the queen in a chess game, make sure you hit.
Yeah.
Because if you don't, they fight back.
I think it's best not miss.
Yeah, best not. Okay.
Best not miss. There we go. Thank you, Eric. Yes.
That's more poetic.
Margaret Williams had a nice zinger here. She said Jones Work should change their name from Jones Work to Hotel California. You can check out, but you can never leave.
That's a beautiful statement. Thank you, Margaret.
Yeah, exactly. But yeah, it just seems funny to me. Like, I'm going to go on the offensive and sue to enforce this contract. Oh, really? Well, it's void. Oh, like
ouch.
Ouch.
And now, not only that, I'm countersuing you, and I'm bringing some claims against you, and we're going to see those claims.
It's like, what were you thinking? So let's go down to page 44, and we'll look at the California Business and Professions Code 16600.
While you're pulling that up, Santana had a good point, and I think we had talked about this. They're saying she read text to other Jones Work employees that were about them, and then she gave them to Leslie. She's referring to Leslie Sloan, which is the
Yeah.
Um,
PR rep.
Yeah, the PR rep
for Blake Lively.
Yeah, Lively's team.
Yeah, and there's actually allegations in here that she read them to the other employees of Jones' work. I mean, that's not right. And then that's part of the breach of privacy that we'll get to in a minute.
So it looks like we have another California code section here that may be protective of Jennifer Abel.
So in California, you cannot prevent it's a non-compete clause in these employment agreements. California will not enforce them. So in California, we do not believe in forcing people to agree to non-compete clauses.
What is a non-compete clause?
That's where you agree that if you leave this employment, you're not going to go and join a competitor and try to compete with me. So, if you sell brake pads, you're not going to leave my company and go to another company that sells brake pads and try to sell brake pads.
Or start your own company to sell.
Right. Or start your own company.
So Jennifer Abel agreed not to compete against Stephanie Jones once she signed the employment contract with Stephanie Jones. Is that right? Is that how that worked?
That was in the contract, a non-compete clause, and California simply will not enforce them except for 3 very limited circumstances.
So it sounds like this is a surprise number 2 for Stephanie Jones and her legal team.
Yeah. Yeah, we're going to enforce this non-compete clause. Oh, really? Because you're doing it in a state that doesn't recognize them. So that doesn't seem like such a great strategy to me either. And if you look at that paragraph 36, they actually go into the 3 reasons, the 3 times you can use a non-compete. And you'll see that it's, for example, covenants arising out of the sale of goodwill of a business or ownership interests in or operating assets of an entity. So if you're selling a business, okay, it makes sense that you can have a limited non-compete. Covenants arising out of the dissolution or disassociation of a partnership. So if you're in a partnership, you can have a limited non-compete. And covenants arising out of the dissolution or sale of a limited liability company. But even within those 3 categories, the non-compete has to be very narrowly tailored. It has to be set to a certain geographic area. It can't be for a very long time. But you cannot just take any employee and say, if you leave this employment, you can't go work for a competitor. No.
What does Brian Friedman say about these exceptions to the general rule that non-competes you can't use a non-compete clause?
Well, they're not relevant. They're not relevant to this case because Jennifer Abel doesn't fit into any of those 3 categories.
Jordan says, aren't non-competes difficult to enforce anyways?
Yeah. They are, especially in California, they're almost impossible to enforce. But yeah, they can be very difficult to enforce, even in the best of circumstances. But it's just not going to fly here. So again, another provision that I don't even understand why Stephanie Jones sued on it to begin with, when it was not going to win.
I wanted to point out paragraph 40 here. And again, this is Jennifer Abel's legal team, which is Brian Friedman et al. And as set forth above, Abel's 2020 and 2021 employment agreements contain unlawful restraints of trade in the form of express non-competition and non-solicitation provisions, as well as in the form of unduly expansive confidentiality provisions. These are unlawful and void ab initio under California law. Now, Keith, I think this is Latin. We got in trouble for our Latin skills once in a while. But what does ab initio mean?
It means from the very beginning. So it's not that it's void, like you have to follow the terms for a year and then it's void. It's void from the very inception. And so you don't have to follow any of the terms of that employment agreement at any time. Nor can any of those terms be enforced against you for that matter. So now we get into these sections, the next several sections.
It's brutal.
It gets brutal. The gloves are coming off and they're talking about just how terrible this situation and relationship was. So what do we have? On paragraph 41 there. So it sounds like the minute that Abel starts on the job, she starts to see that there's trouble in paradise here.
And and I think we're going to get there, but Abel was also warned by people in the industry that she should steer clear of Jones' work. Yeah.
And then it turns out as soon as she starts, there was a huge number of employees. So they say here, allegedly, that left the New York office. And, obviously Abel was concerned.
I think this is interesting. At paragraph 42, Abel observed that morale amongst Jones Works employees was inversely correlated with physical proximity to Stephanie Jones.
That's a very professional way to say that people didn't like being around Stephanie. I mean, that's a more direct way of saying it, I think.
And at paragraph 43, they show there really wasn't a human resources department. It was just people that had other duties that would kind of fill in that function. So there was really nobody you could go to and say, hey, I'm having an issue with the way that I'm being treated. There's a hostile work environment. There's an SH issue. You couldn't do that.
Yeah. So let's look at paragraph 45, where things really start going downhill, apparently. So by Abel's second year, Jones appeared to be deteriorating. Abel began to harbor increasing concerns about her mental stability and ability to manage client and employee relations. Oh boy. So things are getting bad.
And again, this is a great example of how the litigation privilege works. Once
Yeah.
you file a lawsuit, you can say, I mean, it has to be within reason. It can't be just craziness, but you can say a lot of things about somebody and you are immune from getting, well, you're not immune. Somebody could sue you for defamation, but you would have a privilege to say that happened during litigation, and chances are the court would agree with you.
Yeah, it wouldn't be successful. And then she said that Jones became noticeably paranoid and does that say irascible?
Irascible.
Often accusing Abel and others of plotting against her.
So paranoia. It seems like there was, and they talked about that she just quit sleeping, and there was all kinds of issues.
Yeah, and then they also mentioned that there was a slew of clients in May of 2024. A cascade of Jones' work clients began to cut ties with Jones. So you can see that the pressure is on if that were true, according to these allegations. And then there was apparently the Stephanie Jones leaks were posted on X and then taken down and then posted on a few other social media platforms. Now, Abel said she had no involvement of any kind in the Stephanie Jones leaks, but it was terrible information from former employees who were trying to discuss the treatment that they were subjected to by Stephanie Jones.
So Stephanie Jones is becoming paranoid. She doesn't trust anybody. There's a Stephanie Jones leaks. I think it's called Stephanie Jones Lies now. It's on the web. And then what's going on with this article from Business Insider?
Yeah, they did an article in August of 2024, and we read that article, and it really was
It was not flattering.
It was not flattering for Stephanie Jones. And they say right here, always a volatile personality, Jones had become noticeably more paranoid, erratic, and cruel in recent years. And the article actually talks about former employees who were afraid of Stephanie Jones, afraid of speaking up. I mean, it sounded like a very hostile working arrangement based on that article.
Something I talked to about producer Eric today, because I wanted to know if we have the same environment. But apparently at Jones Work, there wasn't a day that would go by in the office that someone wasn't crying.
Yeah.
And I asked producer Eric, is there any crying going on around the office here? I want to make sure we're not having a Jones Work environment here.
Not that I know of. No comment. Just kidding.
It'll be a Ask Two Lawyers leak.
This one also
next.
hit me, Keith, that there's a lot of protections in California, and New York is a liberal state. I'm sure there's similar protections up there. But if this is true, this is inappropriate of an employer to do to an employee. We had people that would say that they were going out sick, and then Stephanie Jones would FaceTime and not just call them, but FaceTime them to confirm that they actually were sick. Like, I want to see you puking in the toilet, I guess, or I don't know what she wanted to see. But the one that really hit me, there was at least one instance where an employee had taken a personal day to attend a funeral.
Right.
And Stephanie Jones FaceTimed the employee, and the employee picked up while they were at the funeral.
Just to prove he was at a funeral.
Yeah. And so if this turns out to be even remotely true, I think, and it comes in before a jury, they are not going to like this lady.
No, that's over the top. I mean, nobody would like that.
Is there anything else on this page you wanted to address?
Well, I think it was interesting at the bottom on page 50, on paragraph 57.
While we pull that up, I want to bring this up. This was seems like a really intelligent comment from Roman, who's really involved in our community, and we thank you. He says, what happens to the Blake Lively / New York Times lawsuits if Jones' work text, in quotes, subpoena proves to be fake? Will these lawsuits proceed or be dismissed?
We were talking about that the other day. And I think what we were concerned about is the evidence is there, right? But it sounds like it was procured in a bad manner. But this isn't like fruit of the poisonous tree in a criminal case where it was produced without reading, the criminal their rights, and therefore you can't use it at all. I mean, you think if there's text messages out there that can be independently sourced right now, I mean, I would think that people would be able to use them.
Well, I think that they could use them if they use a different subpoena or a different type of subpoena. I'm not sure that they could use it based on whatever subpoena they claimed they had. I don't even know what subpoena they had. We haven't seen it. There was no open court cases that we can think of. And you've made the really important point that if there had been a subpoena, you have to give
Notice.
notice to Baldoni and the Wayfarer parties. And what would they do? They would object. If Baldoni and the Wayfarer parties got notice of a subpoena that we're going to subpoena the text between Jennifer Abel and Melissa Nathan, don't you think they would have raised an objection? They would say, wait a minute, those are our agents. That's private information. So
they should have at least been given. Well, first of all, that we have. I think we finally found out that there was not a subpoena, which we wrestled with for a while. We kept asking ourselves a month and a half ago, "Where's this subpoena that the New York Times refers to?" Other people. I looked on the Wikipedia page today, and it still says that these documents were obtained by subpoena. And of course they cite to something, but I don't think there was a subpoena. I think there was a transfer from Stephanie Jones or Jones' work, it looks like, according to these documents. And that's how these documents ended up with the New York Times.
Yeah, because of course you would have objected and there was no objection. But the reason I want to point out this paragraph 57 is through it all, Abel remained loyal to Jones, sticking with her through thick and thin, despite growing doubts about Jones' ability to function professionally. And there is a letter, an email, we'll see it a little bit later, where it looks as though Abel was really trying to be professional, even as she was leaving Jones' work, and even though she was being treated quite aggressively in the process. So good for her if all of that is true, which based on the email, it certainly looks convincing.
So paragraph 60, if this is true, again, this would be something that, again, I hope it's not true, because when I'm reading it, I'm just blown away by it. I'm not usually blown away by facts like this,
Right.
But if it's true, if there's any remoteness of truth here, it's going to be a problem for Stephanie Jones. But Abel was often on the receiving end of Stephanie Jones's often bizarre outbursts. In one instance, Stephanie Jones announced to Abel's subordinates that she had learned through psychic readings that Abel was an alcoholic and a gambling addict.
Wow.
Though just that alone right there, if that's true, I mean, Abel's got a right to sue Stephanie Jones over that. That's just not appropriate.
That's a bizarre statement. Maybe Jones should just stick to fortune cookies and not go to psychics. So now we have, on different occasions, Jones announced again, per her psychic, that Abel would soon be pregnant with twins. Oh, wow.
And apparently Abel had been struggling with having kids.
Oh, that's even worse.
Yeah. So, I mean, if any of this is true, this is going to be brutal. Abel also witnessed Jones working with journalists to plant and contribute negative stories about former Jones Works clients who had fired Jones Works. So it sounds like there's a vindictive individual here. At least that's what they're trying to portray.
That's the picture they're painting with these allegations, and it's painting a pretty bleak picture. Now on this page, we do have those text messages, and that's where I think we've seen these text messages before. But the thing that was interesting is I didn't realize that Stephanie's husband Jason texted Jen's fiance after the resignation to try and keep them together. And I don't know if you can even read that, even if you blow it up. It's kind of hard to read.
It's really small.
But it says, "We can't let another great duo break up. Shoshone and Trout was one thing, but our girls are better together." So I just thought that was also kind of odd that the husband would text the fiance in order to try and keep them together. And of course, we also know that Jason was working for WME, which is the same place where Ari Emanuel was.
In paragraph 62, just a side note, but apparently Abel requested for the Jones Works LA employees to get a modest 2% COLA raise. And if true, Jones told her, well, it's going to have to come out of your paycheck if you want that to happen.
Yeah, that's harsh.
And then already pushed to the brink, Abel finally had enough when Jones demanded that she corroborate falsified accusations against a senior Jones Work employee in an effort to drive him out. And when Abel refused to go along with it, Jones responded with mockery, calling her a 12-year-old drama queen.
It's just terrible. So it just gets worse and worse. And on the next page, we have the email that...
Real quick, how about, not real quick, while we're pulling that up, guys, could Jones have used a petition to perpetrate testimony or preserve evidence as a pre-subpoena type document in reply, talking about the texts?
Possibly. And there was a filing that Blake Lively did in Texas, and it was done in January, and it's under Texas Civil Procedure Rule 202 that allows you to file a petition and get discovery before you file a lawsuit. But you have to get permission from the court. We don't have a provision like that out here in California that I'm aware of.
Not that I'm aware of.
Yeah, I've never been able to file, but could you have filed some lawsuit somewhere and used that to get a subpoena? You could have, but we always circle back to the issue of that's fine, but you still have to give notice to the people whose records you're subpoenaing. In California, we have a rule that requires consumers notice. So if I want to get a subpoena of your financial records and you're not even a party to the case, I still have to send you notice.
And give me a chance to object.
20 days. I have to send you a notice and say, in 20 days, I'm going to be serving the subpoena and you have the right to object. So I don't get it.
I don't think you're going to see the email, but why don't you go ahead and go through what you wanted to talk about there, Keith?
Well, and I don't necessarily want to read through this whole email, but the thing that's compelling about it, I think, is just how professional it is. And if you just kind of come back and take time to look at it.
Professional from Jennifer Abel's standpoint.
Yeah. So Jennifer Abel is talking to Stephanie Jones saying that, I want to thank you, for everything you've done for me. And I've thought about this and this is really what I want to do. So you're not seeing any vitriol here on behalf of Jennifer Abel. And even though it appears as though she's getting a lot of very intense communications to her, she's responding professionally. So good for her.
In paragraph 69, on August 21, 2 days. So Abel had given notice. She'd given 6 weeks notice to Jones Work, which I thought was, that's a nice thing. Then when employees take the time to say, hey, I'm leaving, I'm giving you 6 weeks notice. That way you can close out whatever work you're working on. It makes the employer happy in many cases.
Makes you look very professional.
Makes you look very professional. So 2 days before her last day on August 21st of 2024, just this past summer, Abel pulls up to Jones Work in Beverly Hills, their LA office, and she's confronted. Brian Friedman talks about it, the physically imposing security guard. There's a forensic data extraction technical expert, and there's even an attorney at a conference room table awash with documents. I mean, if he was doing a Stephen King novel, he's doing justice here of giving us a description of everything that's going on. And then, of course, we have, after being ushered into the room, Abel notices that the security guard is being placed between the door where she can leave and where she is in the conference room. And it just, it's a big imposing security guard. To her it is. And she just feels threatened and she's not feeling good about this.
I think that'd be intimidating for anybody, but definitely she apparently felt intimidated and I don't blame her. So it's within that meeting where they have her sign a bunch of documents and they demand to search her laptop because they claim that she took documents she shouldn't have taken. And
they don't find anything on the laptop.
Jennifer Abel goes, fine, search it. I don't know what to tell you.
Yeah.
They don't find anything there. And then they tell her, we'll go ahead and give you your phone number back. Go on down to the Verizon store.
Well, what they say is give us your phone.
Yes.
Because it was a Jones Work phone.
Yeah.
And she had used her number from when she was in high school.
Personal number, business phone.
Right. And I want to tell everybody in the jury pool, if you're ever in this situation, do not give your phone back. Hang on to your phone. And I know that she did her best under the circumstances. You can only imagine how threatened she felt. Security guard, forensic expert, other people there looking at her. She's got an attorney there telling her she has to sign documents, which it still remains to be seen if those will be enforced against her, because it seems like there's some duress there. And she's shown her computer, her laptop, and then they say, give us the phone. And she says, well, will you promise me that if I go down to the Verizon store, that you'll port the number to me and I can keep my iCloud and my emails and my texts and everything? No. You tell them, look, I'm not giving it back to you. If you want to go down to the Verizon store with me and we port the number over and I confirm that the number's ported over, then I'll give you the device back. Now, that's easy in hindsight to say, Keith.
Right.
I wasn't in the hot seat like Jennifer Abel was, but I want our jury pool to know, if this ever happens, anything like this ever happens to you, ask to see an attorney, your own attorney, before you sign any documents. Never sign documents without your own lawyer looking at them. Yeah. And then secondly, if there's a device and there's an argument over who owns that device and you have your personal information on there, I would fight hard to get that personal information back first, and then you're happy to give the device to them.
Yeah, and if they don't let you out of the conference room because it's a security guard, call the police. I mean, you have a right to do that. That's not being, some people might think, oh, that's being over the top. No, it's not. If you're being held captive, you have the right to call the police.
If you're not allowed to leave a place, what do we call that?
It's false imprisonment.
It's false imprisonment.
Yeah. But I can't fault Jennifer Abel for what she did, because it's a very stressful situation. There's a big security guard, and this chief of staff assures Abel that, go on down to the Verizon store and I will give you the number.
Yeah. And
He
this
lies
is,
to her.
and you got to be clear. These are all allegations that are being
Yeah.
made here, but and these will all have to be proven at the time of trial, but this is what the position is that we're going through.
Yeah. And so the allegation is that this chief of staff just was lying to her because she goes down to the Verizon store and they call the chief of staff and he says, oh, yes, just give me a few minutes. I'm going to release the number. And they were supposedly in the process of trying to release it. And then Abel never heard from him again. And after 4 hours of staying in the Verizon store, trying to call this chief of staff, she realized that they double-crossed her.
These are some of our favorite moments in trials, Keith, where we get to represent people like Jennifer Abel. And if there's truth to these allegations, when you get Stephanie Jones in a deposition,
Oh, yeah.
this is some of the funnest stuff that you will ever do. And it's really holding this person accountable for what they did and the harm they caused to this person. Think of the stress that you would go through. I mean, you have a sentimental reason to a phone number. I know that some people don't get caught up in that. I would. It's your number you've had since high school. And then all the personal data that you have on this device that Stephanie Jones or anyone else does not have any business looking at or having access to. And that's, again, the lesson here. And I'm sorry, Jennifer Abel, we have to learn from you is do not give up the device. Hang on to that device at all costs.
Yeah. I mean, it's just devastating. And she couldn't even get into her bank accounts. And because we all have those 2-step authentications now where you need your phone.
I know this is silly, but you knew somebody once that had a device and they didn't want to give it back to somebody. And they were being pressured very hard to give this device back. And it was a female that was being pressured to give this device back. And she put the device down her pants, right?
Yes.
And so why did she do that? I mean, what was her thinking?
Well, because then if you try to get it, it'd be like a worse crime. And so
It'd be assaulting her.
Yeah, it'd be assaulting her.
Yeah. So
I mean,
yeah.
But you do what you got to do. It's unfortunate. I mean, again, like you said, it's easy to see this in hindsight. And, if all of this is true, I feel terrible for Jennifer Abel. She did the best she could under the circumstances, but yeah, lesson learned.
All right. Where you want to go now, Keith?
Well, this was a few minutes ago. This is the Tilted Lawyer. Omar is in our chat with us. He says, again, this was a few minutes ago. You guys might know what this was in reference to, but he said, that's the loan out argument. I don't think it's going to work. Just wanted to shout him out real quick.
I don't know how to respond to that, Omar, but I did watch your channel last night. My girlfriend and we watched for a while and we enjoyed what you had to present. And I think you're in San Bernardino and I think you went to Laverne Law School. And I was in Loma Linda for about 17 years, which is right next to San Bernardino. And Keith and we started our practice in Riverside, California.
And Redlands.
Yeah. And so, Omar, we got to, meet up sometime. We'll take you to lunch and it'd be interesting to talk about this case.
Yeah, that'd be great. So the next few pages talks about the fallout. So now Stephanie Jones has the phone. She's sharing text messages with the other employees. And then the question becomes, where does it go after that? And that's when we get into Stephanie Jones' fallout with Wayfarer and Baldoni. And there's really quite a story here about how Stephanie Jones was never really part of representing Wayfarer or Baldoni.
So essentially what was happening here was you have Wayfarer, who's a smaller client when you think of Dwayne The Rock Johnson or Tom Brady. And they felt through the years, I think Jamie Heath, the CEO, felt that Stephanie Jones would spend most of the time with her hiring clients, and she would have people like Abel take care of the smaller clients, and Wayfarer was a smaller client. But Wayfarer actually liked Abel. They liked what that she did for them. They had a comfort level with her, and she had taken that LA office from like 4 employees to 12 employees, something like that. So she'd gotten raises all along. Jennifer Abel seems to be the real deal here. And so, those are the things that were going on at that time.
Yeah. And then Jones was not around as far as Wayfarer was concerned, according to these allegations.
And then she kind of reinserts herself while on a vacation in Europe, according to the pleadings here. She reinserts herself into the relationship because she realizes Jennifer Abel's leaving.
And she wants to secure the client. And so if we go to paragraph 85, for example, we'll see kind of what the problem was with Jones trying to reinsert herself into this relationship that she'd been absent from. And I'm on page 58. So Jones now inserts herself into the mix in early August 2024. And they say the problem, however, was that Jones had chosen not to be privy to Wayfarer leadership's communication strategy or internal decision making. So she didn't know what was going on. And one of the things that Jennifer Abel had worked out with Lively, or she thought she worked out with Lively, is that they were going to call a truce and nobody was going to try to talk to the media. Now, Jennifer Abel didn't realize that the Lively side had breached that truce. But then Stephanie Jones comes in, according to these allegations, and starts talking to the media against the instructions of Wayfarer and the leadership at Wayfarer. And
Didn't
so-
Jamie Heath say something to her in an email very kindly? Hey, butt out. We don't need your help. We're happy with what Jen Abel's doing for us.
Yeah. And so instead, Stephanie Jones reaches out to the Daily Mail as the allegation, and Wayfarer's leadership was livid. They were absolutely livid that she would do that. And so was Sony. And they both were angry that, thinking that Wayfarer had instructed Jones to do this when in fact they had not. And you can see that on paragraph 88. So Wayfarer's leadership was livid, as was Sony. All parties were desperate to prevent an all-out slugfest between Lively and Baldoni, just as the film was about to be released to the world. And obviously that is the opposite of what happened. And then if you go to the next page, paragraph 90, they allege that Jones panicked about being blamed, and she wanted to call Sony and Lively's PR team to clear her name. Wayfarer asked her not to, and Stephanie Jones said that she could do whatever she wants, and she was going to call anyway. So that's kind of, you're seeing just the animosity between Wayfarer and Stephanie Jones and what was happening in that relationship. And then let's go down to 92. And this is really the big issue that we've been talking about for a long time. So notably, on the same day Abel was terminated, that's August 21, 2024, just hours after Abel's phone was seized, Leslie Sloan calls Melissa Nathan. During that call, Sloan told Nathan that Sloan had seen Nathan's text messages, which could only have come from Abel's phone, and that Nathan should expect to be sued.
And if true, this comes back to, what is revenge and when's the best time to serve it? Is it good to serve it when you're angry and upset?
Cold?
Yeah.
Dish best served cold?
Yeah. You want to take some time to think about it. And I think that, Stephanie Jones made a mistake here by probably being infuriated by what she saw and getting angry, and then emotionally responding, acting to it. And we all would be angry. We all would want to respond to it. But that's where sometimes, and this is a tip for the jury pool too, when you're angry and you want to respond to something, don't. Okay. When somebody tells you you're ugly, stop. Okay. Because you're not ugly. You're beautiful. But the point being, don't react to emotions. When you have an emotional response and you want to fire out at somebody and it feels so good to do it in the short-term moment, you're almost always afterwards saying, why did I do that? So just do the opposite of what your emotions are telling you. Go to a separate room away from everybody, scream and yell all you want there, but hold back and take some time to calm down and then think about how is the best way to respond.
Yeah, and especially in professional settings. I mean, this certainly would not, if this is truly what happened, these allegations are true. I mean, it's a horrible thing. And the thing that surprises me, it's just so shocking, because as lawyers, we're not allowed to disclose any confidential information that we learn about a client, even if it doesn't have anything to do with the case. So we could be representing somebody on SH claims, and they could come in and say, when I was 18, I had a child out of wedlock, but I never told my wife, when I got married and when I was 25, I never told her about this child. That's confidential information. It has nothing to do with the claim necessarily, but now that you've been told that, we as lawyers have to keep that in confidence. Even after we stop representing the client, how long do we have to keep confidential information confidential?
Forever,
until the day we die. And so that's what's just so shocking to me about this is I'm going to take these text messages between my employee and somebody that we hired, an agent of both my firm and Wayfarer, and I'm going to disclose them to the world. I mean, it blows my mind.
And what about the idea here that Wayfarer and Stephanie Jones and Jones Work had a contract between themselves? And that contract, you may be getting there. Maybe I'm taking your thunder here. I hope not. That contract had a confidentiality provision in it, right?
Yes. And that's what I had mentioned on one of our earlier videos is I'd love to see the contract between Jones Work and Wayfarer. Well, it actually is part of it is recited in the countersuit that Wayfarer filed against Stephanie Jones. We'll look at that in a second, but it did have a confidentiality provision in there. And so I think that there's going to be some big problems for Stephanie Jones if this allegation on paragraph 92 is true that she disclosed this.
All right. Paragraph 97.
Here we go.
Go ahead. Read it out, Keith.
On information and belief, Jones turned over the contents of Abel's phone to Lively and her team without a subpoena so they could slice and dice her communications to construct a false narrative about the source of Lively's bad publicity. So they're saying it was without a subpoena, but what does on information and belief mean?
This is an important point, everybody. When you're reading these complaints and these answers, when a lawyer says on information and belief, what they're saying is we don't have a document in front of us that
we're not sure.
We're not 100%, but we believe it to be true because it just makes sense from the evidence we do have, or from what we've been told by witnesses. We've called and talked to people. We just have a belief in this case that Stephanie Jones took the phone and turned this stuff over to Lively's team somehow, some way, and then Lively's team, whatever they did with it, New York Times, whatever, that's for a different case. But on information and belief, when you see that, what somebody's saying is, look, I really believe this to be true. I'm just not 100% certain, but with some time to do some discovery and take some depositions, I believe I'm going to be able to prove this.
And it's a little hard to prove because you have to prove a negative. It's easier to prove something that happened. There was a subpoena that issued. How do you prove something that didn't happen? A subpoena was never issued. It just takes you more time because you have to track down all potential sources to see if there's any positive subpoena out there. And then ultimately, if you don't find one, then you've proven the negative, but it's harder. It
is. And one last reason I like to plead on information and belief on these types of facts, Keith, even though I'm pretty sure they're true or they're close to true, is what if I'm not 100% true on what the allegation is? Maybe I'm 80%. And so I have just a little piece of it that I was wrong on. This gives my client some coverage at deposition.
The wiggle room.
The little wiggle room when they're saying, you made an allegation that Jones turned over the contents of Abel's phone to Lively and her team without a subpoena. And you could say, that was my lawyer. And they said that they believed that and they put it in on information and belief. It takes away the fire from the other side when they're taking your deposition.
Yeah, it takes away the sting. So it's a smart thing to do. And you see it a lot in complaints. But what it does tell us is that we don't know. I don't think that they know with 100% certainty that it was without a subpoena. But again, hard to prove a negative. So it's going to take some time to do that. So what
would happen if it does get proven down the road? That's what RSLE was wondering. If you were to make a judgment.
Well, it's going to strengthen the case that Wayfarer has against Stephanie Jones, and it's going to strengthen the case that Abel has against Stephanie Jones. I mean, she's going to get, in my opinion, she's going to get clobbered.
Yeah. If all this is true, Eric, as it's being pleaded, and again, there's a court of law, there's a jury that's going to hear all of these claims. And of course, there's still discovery that has to be done. But if all this is true, I just don't see how Jones Works makes it through this.
Yeah.
It'd be pretty tough to make it through.
Yeah. Because what are the damages? I mean, they got to be immense at this point.
Yeah.
If it comes to be true.
Thanks.
So the causes of action are pretty obvious based on what we went over. So the first one.
Can I jump in here real quickly,
Yeah.
Keith? Just from stepping back so people can kind of understand how the sausage is made. We're seeing 101 paragraphs up to the first cause of action.
Yeah.
Is that just the facts that we're trying to present to the court if we're the lawyers here so the court has a flavor of what's going on?
Yeah. It's a factual basis that you're making the complaint. It's also the facts that you're going to use to base your legal claims on.
And then why is there like the paragraph at 102? Why is that after every cause of action? After the first cause of action, the second cause of action, third cause of action? Why is that paragraph 102 there?
Just to be on the safe side, so that if you do get a motion to dismiss and you say that, well, you didn't plead a certain fact, you can come back and say, well, under the first cause of action, it includes every fact I said from paragraph 1 to paragraph 100. And the second cause of action includes every paragraph I said from paragraph 1 to paragraph 100. So it just kind of shortcuts so you don't have to restate all those factual allegations. And this first cause of action is declaratory relief. So what they want the court to do is to make a finding that the 2021 employment agreement is null and void.
Keith, your $2 words are getting to me here. I don't know what declaratory relief means. Can you explain what declaratory relief means?
So that's where the court will come out and render an opinion. Most of the time, courts are not allowed to just give opinions. They have to make decisions for either the plaintiff or the defendant. But there are certain statutory allowed areas where a court can come out and make an opinion. And that's what a declaratory relief is. So the,
So the
court
court
is going to declare.
Sorry, I got in your way there. The court's going to declare something.
Yeah.
And here they're asking the court to declare what?
That the 2021 employment agreement is invalid.
Based on?
It's the California Labor Code section 925 that we looked at earlier. And it's because the employment agreement cannot require an employee to adjudicate outside of California, and it cannot deprive the employee of the substantive protection of California law. And if it does, there it is, A1 and 2. And if a contract has either one of those two provisions, then the employee can seek to have the agreement voided. So it's voidable by the employee.
And then, of course, there's subsection C there, that if you are successful as the employee under this, the court may give you your reasonable attorney's fees.
That's right.
Are you wanting to go through each one of these causes of action?
No, 925 is pretty much the same. The next second cause of action is the same. So it's just they want the court to find that the agreement is voidable, and that Jennifer Abel has deemed it to be void. The third cause of action is another declaratory relief. So again, they want the court to render an opinion that all of the non-compete provisions under the agreement make the agreement void, and those non-competes will not be enforced. So that's another type of declaratory relief. And then this is kind of interesting. On the fourth cause of action, we get to unfair competition. So they're using California Business and Professions Code section 17200, which is a pretty expansive code. And it's used for a lot of different things in California when it comes to unfair competition, unfair business practices. But essentially what they're saying is that using contract provisions like these are so blatantly illegal that really what you're doing is you're engaging in unfair competition. And so they want damages for that. And this is the sixth cause of action, invasion of privacy. So I'll tell you what, this one is the one that I thought would be in here, and I really like because of the disclosure of all the text messages to the employees at Jones Work or anything else. Yeah, so essentially what we're saying here is that Jones and Jones Work intentionally invaded the private affairs of Abel by accessing, copying, disseminating, publicizing the contents of her personal cell phone. I mean, how devastating is that? Yeah. How would anybody feel if you went, like if I went into your phone and just took all of your text messages and passed them out? I mean, that would just be so violative.
I don't know how other people feel about this, but I'm not going to commit a crime, but I'd want to strangle somebody.
Yeah.
I mean, I would be so angry to think that somebody would be, that awful to me to disseminate my private communications. And, we have a reasonable expectation when we work for somebody that they're not going to do that. And that's what Brian Friedman and his team say here. And they also say that the invasion of privacy here was highly offensive and objectionable to the reasonable person of ordinary sensibilities. Why do we talk about, first year tort question, why do we talk about a reasonable person and their ordinary sensibilities? What are we getting at there?
That's typically the reasonable person standard. And so a lot of different laws use the reasonable person standard. And so you hold up the action to what would a reasonable person do? Would a reasonable person take somebody's phone, take all their private text messages and pass them out? And ultimately, that's for the jury to decide. But boy, I would think the jury would say, no, a reasonable person wouldn't do that.
And would a reasonable person feel harmed by the fact that somebody sent that out? And so the reasonably prudent person standard is just, it's supposed to be an objective standard of a subjective damage that somebody goes through. And so if that makes any sense, but the idea is there that if let's just say that Abel was highly susceptible to being upset by things, damages may not be awarded to her because she's just too highly upset. But here, I think Friedman does a good job of saying, look, you have reasonable expectations that if you work for somebody, they're not going to take your cell phone that was a company issued cell phone with your personal data on it and use it against you in such a horrific manner. Yeah.
And these are very fact specific inquiries. So if I took your phone and you had a picture of your dog on your phone and I shared that with everybody, and that's all I did, would a reasonable person be harmed by that?
Probably not.
Probably not.
It's a little invasive, but you're not, it's not that big of a deal.
But if I took all of your personal texts between you and your girlfriend and I shared them with everybody, now that's a whole different story.
Different
that's a
ballgame.
huge violation of trust.
And Keith, I saw that the 8th cause of action had intentional infliction of emotional distress, and then there was negligent infliction of emotional distress. These are the torts here that are included. And IIED, the idea is that Stephanie Jones here intentionally tried to harm this person, intentionally tried to hurt them and harm them in a way that was not reasonable, in a way that you wouldn't expect somebody to be able to undergo.
Yeah, and it's where somebody suffered severe extreme emotional distress and mental anguish as a result of the conduct. And the difference between intentional and negligent is obviously with intentional, Jones would have to have the intent to cause that harm, whereas on the negligent, you can do it without the intent. You can just do it with disregard for somebody and their feelings.
And I think they're just throwing this in here, but why not? We got false imprisonment.
Yeah, I liked it. I thought it was a good cause of action because of that security guard and the fact that they forced Abel to sign those forms. So Jones and Jones' work were aware that the other plan was this to commit a tort of false imprisonment. Oh yeah, well they definitely planned it because they had the security guard there ready to go. It's not like the security guard just popped in out of nowhere. So I thought the false imprisonment was a good cause of action. I don't know if that's really going to get them a whole lot of damages, but it certainly goes hand in hand with everything else that happened.
And is there anything else? I think we're done with that.
Yeah.
We've already been going an hour. It looks like people are still hanging in there. We wanted to cover just briefly the Wayfarer versus Jones, and then we wanted to talk about Jed Wallace's declaration. I almost wonder, do you just summarize what happened in the Wayfarer?
Yeah, because I think this captured it. And, the Wayfarer versus Jones captured pretty much all of the same factual basis that we've already seen here. And there's only two things I wanted to point out with that. One is they also allege that there was no subpoena, just as we saw here. And number two, they showed that confidential provision that Wayfarer had with Jones Works, which is going to be important because I think that establishes that Jones Works had a responsibility not to disclose this information and did it anyway.
Okay, so we can go over that further if people want more on that. I think the real meat and potatoes here was the Jennifer Abel versus Stephanie Jones. We'll get all the documents over to producer Eric. He'll put them under the description in YouTube. You can download them and read them to your heart's content. We did want to briefly talk about Jed Wallace. And Keith, I will tell you, I didn't know much about Jed Wallace until I read his declaration today. But there is one person in this case I do feel bad for. I feel bad for everybody to some extent, but I really feel bad for Jed Wallace. I think he got caught up in this according to his declaration. And the reason I believe that firmly is that he's sworn in the statements he makes in this declaration, which we're about to look at. He makes them under penalty of perjury, meaning he can be beat up with these later in deposition and at court. And you don't normally see, like Blake Lively and Justin Baldoni, nobody's coming out putting declarations out right now because they can be torn apart. They can be used against you later on. But I really feel bad about the things that he shared in this declaration. And do you want to walk us through it?
And the declaration was attached to his motion to dismiss. And you do get the sense that he truly was caught up in something that he had nothing to do with. And so we kind of I was starting on paragraph 10. And the reason he's filed this declaration is because he wants to show that he should not be sued in New York. He's Texas resident, does business in Texas. But on number 10, he actually says this is his company, Street Relations, is a crisis mitigation firm engaged by clients to help navigate real-life human crisis, threats, trauma, and mental health concerns. And he specifically says, I have read Ms. Lively's amended complaint, and so I'm ready to kind of talk about it. Let's go over to number 17. So he's hired by Melissa Nathan, but he says, look, on number 17, neither I nor Street posted anything on social media on behalf of the Wayfarer parties or about Lively, Reynolds, It Ends With Us, or any of Lively or Reynolds' businesses. So he didn't do any of those things. This is his sworn declaration. This is actually evidence. This is what he's going to testify to at deposition or trial. Then on 18, Neither I nor Street have ever asked or directed anyone to post about, comment on, or like any social media post about It Ends With Us, Wayfarer, Justin Baldoni, Blake Lively, Ryan Reynolds, or any of Lively or Reynolds' businesses or family. So we didn't do any of that. Number 19, I never published directly or indirectly any information or content, negative or otherwise, regarding Lively. So you're starting to get the flavor of, I didn't do any of this stuff. Number 21 is kind of my favorite. I do not have a digital army in Los Angeles, in New York, or anywhere else. So he's like, I don't know what you're talking about. I have no army.
And 22, I have no understanding of what a social combat or social manipulation plan could be. Or he says, I have an understanding of what those could be, but that is not a service I provided related to It Ends With Us, Wayfarer, Justin Baldoni, Blake Lively, Ryan Reynolds, or any of Lively's or Reynolds' businesses' families. I do not specialize in executing confidential and untraceable campaigns across various social media platforms including TikTok, Instagram, Reddit, and X to shape public perception.
See, and that's where I think, the CRD complaint, the allegations that Lively made, and then they were picked up by Megan Twohey and the New York Times, and they really kind of gave me the impression that this Jed Wallace guy did exactly what he's saying in 23 he didn't do. But that's where you start to feel bad for somebody. I mean, this is his sworn declaration under penalty of perjury. He's like, I don't even specialize in that type of service. But let's go look at the top of page 4, because I think this is interesting. So this is what he did. He's like, I reviewed all forms of media. I analyzed the sentiments of the coverage and then provided updates on my observations. And then most times my feedback took the form of informal comments that I made to Miss Nathan, who I understood to be in California. Again, he's trying to say I'm not in New York. After passively observing the social media environment, I saw an organic outpouring of support for Justin Baldoni and the film. And this observation led to my comment, we are crushing it on Reddit. So in other words, we're crushing it in terms of everything looks good, not we're crushing it in the terms of my digital army is moved out and is conquering. So he says, my feelings based on what I saw was that no actions need to be taken at that time, and that everyone should let the sentiment on social media unfold organically. So, and this kind of brought me back to, and I've had this thought several times where I'm thinking, why would Justin Baldoni pay for a smear campaign when it appears as though, the bad press that Blake Lively was receiving, he was getting that for free. So why would you pay for something that you're getting for free? She was doing a great job on her own. Now she's saying all that bad press was because of Jed Wallace, but you can see here, he's pretty emphatic that I don't even provide that service. I don't know what you're talking about. My only job was to look at the coverage and summarize it. And that's what I did.
Is there anything else you wanted to cover?
No, what do you have?
I mean, this is the part where, all of this, I started feeling bad for him. But he says, look, travel to and from New York would be difficult financially for me. He's in Texas. And at 36, he says, I believe my financial resources pale in comparison to Blake Lively and her husband, Ryan Reynolds. And I just, it feels like this guy got hired to monitor the social media that was going on. And he reported back and said, hey, it's so good. Let's not touch it. Let's let it grow organically. People are seeing the truth in this case for themselves, and they're coming to their own conclusions, and they're siding overwhelmingly with Justin Baldoni. And somehow he got caught up in that he has this secret army, this silent army, this ability to, turn people against Blake Lively somehow, some way. And, he only worked on the case from August to about November. So I don't know how much he was paid. It probably was not much. And yet he's going to have all these legal fees now.
Yeah, he's caught up in a huge lawsuit. He did file a lawsuit in Texas federal court for defamation and declaratory judgment against Blake Lively. And he also there's a section in his declaration that's redacted. And I think it's because, and they said this with a separate filing, that there's medical information in there. So I suspect that he's probably suffering from some medical condition that makes it difficult or maybe even impossible for him to travel to New York. But they luckily redacted that for him so the world doesn't have to see it, which is good. But it does give you the sense of this guy does not seem like some criminal mastermind to me. Seems like just some, guy who works probably on the internet and does what he does.
And we do see this from time to time in the cases we work on where somebody gets caught up in a lawsuit. And unfortunately, it costs them a lot of money and emotional time and energy. It's taxing.
Yeah.
It's a lot of sleepless nights. It's frustrating. I can only imagine what Mr. Wallace must be going through. Again, the thing that I like about this declaration he did is there's 3 times you're going to hear from a witness in most cases. And you only really are going to hear from them in 2 of those 3. The first vehicle they can use is a declaration like Mr. Wallace used here. Sworn testimony. This can be used against him later. Everything he says in here, people will parse. Everyone will take every little sentence and make sure that it's actually true. But he's saying, to the best of my ability, this is the truth. The other time you hear from a witness is in deposition. And usually you're dragging them in front of you and they don't want to be there. So it's an involuntary conversation that you're having with another lawyer who's there to hurt you and harm you and to go after you. And then the third time that people will hear from you in a case is at trial. And so these declarations are completely optional. And that's why you don't see a lot of them being done. And here, my feeling as Wallace is like, I have nothing to hide. I don't have a lot of money compared to the people that are in this case. I think I've been caught up in a soap opera here that I should not be caught up in. And I just want to be left alone and I want to be let out of this. And so that's why I said my heart goes out to him. I also feel bad for Jennifer Abel if everything she is saying is even in the realm of truth, in the ballpark of truth. I feel bad for what happened to her, but my heart right now is with Jed Wallace.
And as lawyers, we never allow our clients to sign declarations unless we feel confident that they're saying the truth, because it can be used against them later at deposition or testimony at trial. So we're always very careful with these declarations, and we go over them many times with the client before we sign them and file them with the court.
Producer Eric, how are we doing? Do we have any questions?
We're doing great. Yeah. What do you say we wrap up with some chat questions and comments?
Sure. Is there any question that we missed? Because I know that the Katie without a crystal ball, that was just on fire yesterday on the internet. So anything that we can pick up now, let's do it.
Here, we'll start with this. We were talking about the documents earlier, and I don't know if this is public or what, but if not, we can link it. PDF for the CRD reply to Blake Lively's complaint. We've put a lot of documents in our episodes before, but
it's my understanding that the filing in New York by Blake Lively is almost verbatim what she gave to the CRD. That's my understanding. So if you want to see that, it's in the New York filing, right?
Yeah, and the CRD complaint can be found by the link on the New York Times article. I'm not aware of any reply to the CRD complaint within the CRD agency, if that's what you're talking about. But in terms of the actual CRD complaint, yeah, that's where it would be found.
Okay. And we'll include everything that we discussed today and we went over today in our episode description so everyone can follow along. If we want to get to this for a second, again, it was sort of the question of the day. Can the 47.1 provision work for a loan-out agreement with a person self-employed and not an employee of the company you are suing, a la the whole, contracted Blake Incorporated topic?
I think it can be if you're making it. Remember, 47.1 talks about any communication indicating or about an incident of SH. It's so incredibly broad.
And the issue there, Keith, I think is what the question is, if you're an independent contractor versus an employee, can you still make that claim under 47.1?
I think you can.
Or do you still have that privilege under 47.1?
I think you can. I think anybody who's making any communication about an SH incident has that privilege. I mean, that's how broad it is.
I agree.
Mm-hmm. I thought this one was funny. This was at the beginning, but Valerie said, learn Italian. The only places they prefer English are Florence, Rome, and Venice. Everywhere else they appreciate Italian. So
nice.
Good to know.
Bene.
Yeah. And this one really got me in the first half. A member said, it's bedtime here, and I left my husband and kids to walk and listen to this. At first I was going, what?
Yeah.
Well, we want you to go, and we want you to go back to them.
Yeah.
But thank you for listening.
Well, thank you very much.
This is from Traveler Landed. Really appreciate getting to know you two. Very professional, knowledgeable, and I enjoy your camaraderie. Great vibe. Thank you. And we appreciate you guys.
Yeah, thank you.
And whilst I'm a pacifist now, I now want clobbered merch. Oh yeah, I meant to bring this up. Check this out.
Oh yeah, let's see the merch. Yeah,
some things we're cooking. It's not public right now, but I think
perfectionist producer Eric is still
we
tweaking
got
this
jury
design,
pool,
but I like it.
Well, I think we're going to have both black and white, and then 12B6 for everyone.
Yeah, I
and
like
then
that. That's
ask
funny.
2 lawyers on the other side. So
yeah, nobody would even imagine that they have 12b6, but
Yeah.
now you're in the know.
Well, great. That was a long one.
Yeah, it was a long one, but we covered a lot, and I'm glad we went over that. I know people were asking us to cover that, and I'm glad we took the time to kind of go through it and explain it. I think it was interesting and illuminating and helpful.
One thing that this has done for me, Keith, is I've been exposed to YouTube in a way that I never had before. And there are so many content creators out there, and they're all doing their level best to bring light to this case. And I'm thoroughly enjoying it. It's a lot of fun. I hope we're bringing some education to the case too. What we really want is for people, from our perspective, to know what we understand about the law, and then be able to take it to their conversations they're having with other people and have intelligent conversations about this, rather than just simply saying, I'm against you because you like this person or you don't like that person. Have some reasons for why you believe in something, and have some reasons that you can explain to somebody else. And we call that arming the jury pool.
Yeah, and isn't it interesting how it heightens the understanding and discussion? So we've gotten a lot by watching other content creators, and you always pick up different nuggets and angles that you can use, and it just kind of increases our own knowledge and understanding of it. It's been fantastic.
It's almost been too fun for us.
Yeah.
I actually read on Reddit that some people find us boring.
Oh, okay.
But most people say that no, they're not boring. It's interesting, and they like us. So, I
mean, we're lawyers. We can't be that exciting.
So listen, thank you so much for everybody that joined us today. Please keep your comments coming. We don't normally ask this, and I don't know if we should even ask it at the end, but if you want to like and subscribe, we would not be upset by that. But we're not going to sit here and beg for it. We don't get anything really out of this. We have our own day jobs that we live off for our families and support ourselves with. This is more of a hobby for us, and we're really enjoying it. But we get to talk to more people if you like and subscribe, and you put comments and you put our name out there. If you're willing to do that, we would appreciate that. We don't require it. We just want to have a great community, great conversation, great education, learning, and of course, respect for each other, even when we disagree. It's okay to disagree, even strongly disagree, but let's do it with logic. Let's do it with love. Let's do it with care for one another. And I think we'll make ourselves a better community.
Yeah, absolutely.
We'll see you guys next time.
Have a good afternoon.